Another issue to be raised is also in 2001, my mother sold her house in Florida. She came home, put $20,000 into a savings account that she was going to use to buy a car. The bank had her sign it, fill out the forms, and she thought she was saying if something happened to her, I would get the money. But they actually put it down that I was co-signer on the co-owner of the account. They also had my Social Security number from years before when I had an account with them, so they just tacked it on. My mother never gave it to them because she didn't know what it was. Support collection unit comes in and snatches the full $20,000 to be applied to my child support. The argument was, now this went on, just so you know, for about 9 years, 10 years. This lawsuit, from my mother trying to get her money back. I never signed any documents. I never added to the account. I never withdrew to the account. I didn't even know about the account. I had nothing to do with it. It was a convenience account for my mother, as they would call it. Even though they claimed it was a joint account, as a joint account, she's entitled to half of the money. Saratoga County refused, the support collection unit and the county attorney, Mr. Kuferman, who ended up afterwards becoming a judge, obviously, were holding on to the money. What they were attempting to do was, we'll give you back half your money, but you give us the other half. Now, isn't that sort of like extortion, trying to keep somebody's money? They had no proof. There was no documents in the bank that I had ever done anything. All the forms they had, my signature isn't on anything. We went to the court, went in there, got a judge. First words out of his mouth, you sued me once. Do you have a problem with me hearing the case? Why would I have a problem? No matter what judge, I'm probably going to get the same ruling. Except this time I actually got a ruling in my favor, which was amazing. And I'll tell you what I think turned it. So I'm in there and the judges asked me a question if I'm going to appeal. I said, how can I appeal it? One, it's not my money. I never had anything to do with it. It was my mother's money. She put it into the account. I can't sue anything. I don't have an interest in anything if my mother lost. But what if she agreed to it? Well, I wouldn't be happy with it, as I told them, but there's nothing I can do. It's her money. So this went on. Well, that part happened after about 9 years. What happened was, the support collection unit decided, well, they're going to put pressure on me. So, now, I had a court order. At that point, I had no child support, but I had a court order to pay $30 a week on arrears. I was paying it. The place I had worked at prior to that, where it was an income deduction order, folded and went out of business. So I started doing more of this type of work. What happened next was, to help things move along according to them, they suspended my driver's license. They figured, well, if he can't drive, maybe he'll talk to his mother about giving her $10,000 and she can get her $10,000. Not going to happen. I don't pay blackmail or extortion. Succumb to extortion like they want you to. I went 9 months without a driver's license. I didn't drive. I couldn't. I'm not about to get arrested for unaggravated license of a car, driving without a license and stuff like that. So I didn't drive for 9 months. Finally, I ended up having to open an LLC. As soon as I opened it up, don't I get a letter from them stating that they now want my LLC to pay the child support. As soon as they did that, I wrote a letter to them. You now have an income deduction order, being able to collect the money I want my driver's license back. Relentlessly, they gave it back to me. They had no choice because of the statute. So we go into court. As I said, the judge asked those questions. The court decided that after I presented the following information. I walked in there and I was looking for something else in the Saratoga County Clerk's office. This is why it's always nice to go to the clerk's office, because sometimes you get pleasantly surprised. I found out that my ex-wife had not one, not two, but 3 judgments against her by the County of Saratoga, totaling about, this one here is for $1,000, this one here is for $1,006, 740, and another 1,037. That she got the county to pay her NIMO bill. Now, she's making $25,000, $30,000 at this point. She's got a free house, and she's claiming poverty, which she always does. She's great at it. As I told you before, oh, and I did forget to mention that 4 months after the family court proceeding, she went out and bought herself a used Firebird. Her insurance premium a month was $200, but she has no money. But there's $1,000 or $1,500 a month going into her account. The judge not only rewarded my mother by giving her back all of her money, but I also made the argument that it is child support, not mama support. The judge actually ordered that the support was to go directly to my 3 children and not to the mother. She was livid. Kids were happy. So all the child support they were starting to collect after that, the $30 a week plus whatever else they could nail here and there, which they did, went to the children and did not go to her. So there's always make the argument. You know, you got to follow through on everything. Now, we're going to start with state penal laws again. We've already gone over issuing a false certificate for these judges and their court orders. Official misconduct. Now, tampering with physical evidence is a Class C felony. Believing that certain physical evidence is about to be produced or used in official proceeding or prospective proceeding and intending to prevent such production or destruction, or by employing force, intimidation, or deception against a person is a Class C felony. One of the things was in my last criminal proceeding was spraying the court with chicken manure. When the person from the television station was there, I gave him an envelope, which also included all my newspapers, which again are on my website. They could have been admitted into evidence when he took the stand. But my attorney deliberately wouldn't allow them to be admitted into evidence, because that would have gone to my intent. And they were given at the scene. I gave the same papers when I was arrested. Well, I turned myself in. I got a phone call. That happened about 5:45 a.m. in the morning, I think it was. Around 9, 10 o'clock, after an hour and a half, I left. I figured the cops aren't showing up for it. Nobody called the police. I went home. 9:30, 10 o'clock, I get a phone call. Were you at it? Yes. Would you mind coming down here and turning yourself in? Nope, I'll be down in about an hour. Well, can you make it any faster? I'm doing them a favor. I'm making things easy. I went down there, I had the newspapers. My attorney wouldn't. Now, I'll bet you anything that the court or Saul Greenberg or something got to Louis Oliver to not admit that stuff into evidence, to show the jury what was behind my intent. My intent was to expose the corruption in the judiciary. Larceny. Property means any money, personal property, real property, thing of evidence, a debt or contract, any article, substance, or thing of value, including any gas, steam, water, electricity. Obtain includes, but is not limited to, the bringing about a transfer or purported transfer of property or of a legal interest therein, whether to the obtainer or another. My mother's house, taken from her, and her portion of the house taken from her and given to my ex-wife by giving her exclusive control over it. Deprive. This is under larceny. To deprive another of property means A, to withhold it or cause it to be withheld from him permanently or for so extended a period or under such circumstances that the major portion of its economic value or benefit is lost to him. They let her stay in that house from 1986 to I think it was 99. Had to pay all the expenses on the house, received no money. The mortgage payments varied from $967, I think, down to maybe $800 a month. And they said, well, you'll get your money back. How do you get your money back when you're paying that out a month? That's like $7,000 to $10,000 a year, plus the other expenses on the house. To dispose of the property in such a manner or under to render it unlikely that an owner will recover such property. The big one here is to keep it from you. Appropriate. This is under the penal law. To appropriate property of another to oneself or a third party means to exercise control over it. Yes, she exercised control over it. She had exclusive possession of property that wasn't hers, and Judge James didn't have the authority to grant her it. Every judge covered up. They all said I'm responsible for providing housing, but I also have to pay full child support, which totaled more than my income. Or permanently or for so extended a period of time under such circumstance as to acquire the major portion of its economic value or benefit. It eclipsed all of its economic value or benefit. There was no benefit or economic value in the house after the court got done with it. Owner. When property is taken, obtained, or withheld by one person from another person, an owner thereof means any person who has a right to possession thereof superior to that of the taker, obtainer, or withholder. My mother had a superior right to that property over Judge James, who took it, my ex-wife, who was the obtainer or of the property. This is under larceny terms. And the judges are all involved in it by covering it up. Larceny defined. A person steals property and commits larceny when, with the intent to deprive another of property or to appropriate the same to himself or a third party, he wrongfully takes, obtains, or withholds such property from the owner. That's exactly what the Family Court and the Supreme Court of New York State did, and the Appellate Court and the Court of Appeals, by allowing my mother's property to be taken and kept by my ex-wife from 86 to 99. Larceny includes wrongful taking. Judge James had no authority to issue his order. Family Court does not have jurisdiction to determine possession of marital property. And this wasn't even marital property. Obtaining or withholding of another's property with the intent prescribed in the subdivision committed in any of the following ways. Conduct here known as common law larceny by trespass or taking, common law larceny by trick, embezzlement, or obtaining property under false pretense. That property was obtained under false pretenses, Judge James claiming he had authority to do so, which he knew damn well he didn't. by extortion. A person obtains property by extortion when he compels or induces another person to deliver such property to himself or a third by means of instilling fear that, if the property is not so, the actor or another will engage in other conduct constituting a crime. They did commit a crime. They had no authority. I was ordered to pay more than I was required by law. Accuse someone of a crime or cause criminal charges to be instituted. I've been charged several times for failure to pay child support, but everything is done in secret and in violation of the law. Testify or provide or withhold testimony with respect to another's legal claim or defense. They covered it up, all of them. Use or abuse his position as a public servant by performing some act within or related to his official duties, or by failing or refusing to perform an official duty in such a manner as to affect some person adversely. Every one of these judges, the appellate court judges and the Court of Appeals judges, including Judge K, are involved in this. It's right there. They failed to do their jobs that they are required under law to do. Perform any other act which would not in itself materially benefit the actor, but which is calculated to harm another person materially with respect to his health, safety, business calling, career, financial condition, reputation, or personal relation. Financial condition in this. They were set out to harm my mother. And they were set out to screw me over. And every other father in court, because this is what they do. They have the fathers agree to pay the mortgage, or they tell them to do that, then they hit them with full child support, and then they tell them, oh, you're not entitled to a refund. They strip the fathers of their incomes. And they say, oh, it's only for a month. Right. Grand larceny in the third degree. A person is guilty of grand larceny when he steals property and when the value of the property exceeds $3,000. It's a D felony. The house is worth more than $3,000. The mortgage payments and all that exceeded $3,000. Grand larceny in the second degree. A person is guilty in the second degree when he steals property and when the value of the property exceeds $50,000. Or the property, regardless of nature and value, is obtained by extortion. Both of these apply. I'm being threatened with jail. My mother's, the value of the house is more than $50,000. That's a C felony. That's why they're covering it up. They don't want to put a judge in jail for corruption for C felony while sitting on the bench. Now, oh, one thing let me also mention too. Separation agreements. Never ever do an agreement on the record in the courtroom. You will be screwed. As I think I said this before, but I just want to re-emphasize it. They will cut, they will interrupt and say we need to go off the record. Stuff never gets on. Always demand that the agreement on the record be put in writing, that you're not agreeing to anything unless it's in writing. And you have to stick to your guns on that. Otherwise, they're going to run all over you. They will threaten and intimidate you to agree to it. If they're going to do that, then you start saying, I'm told, and I'll tell you, this works. I was told that if I didn't agree to this, this, and this was going to happen. Now you got it on the record. The only thing you got to worry about is the judge going in and altering the transcript. As I stated before. Now, after I got released for spraying the Court of Appeals with chicken manure, where I worked at the ski shop. I was selling skis and ski boots and that type of stuff. One of the detectives, Jim Horton, who was involved, I believe, in when I set off the smoke bombs in the Empire State Plaza, used to like to come in the store. And one day I'm in the back room with him, and he says, "Well, tell me, was fighting for your cause worth going to jail?" First off, Jim, I couldn't say that because I'm on probation, and you never know what he was going to tell the probation officer. So I didn't say anything. I didn't even answer him. First off, if Jim had done his job and investigated the corruption, I wouldn't have had to spray the Court of Appeals with chicken manure. Because it is a chicken shit court, just so everybody understands that. But he, and then he goes on to tell me he got promoted. He is now one of Elliot Spitzer's on his security detail. Well, we all know what happened to Elliot Spitzer. He got caught in bed with Miss Dupre and had to resign as governor. Now, the question comes down to, was he on the security detail that took Governor Spitzer to meet with Miss Dupre? Because he's got a 24-hour security detail that watches over him 24 hours. So, I looked up, what else? Prostitution. A person is guilty of prostitution when such person engages or agrees to offers and engage in sexual conduct with another person in return for a fee. So I guess Elliot Spitzer fell into this group. Patronizing a person of prostitution. Person patronizes a person for prostitution when, pursuant to a prior understanding, he or she pays a fee to another person as compensation for such person or a third person having engaged in sexual conduct with him or her. He or she solicits or requests another person to engage in sexual conduct with him or her in return for a fee. Well, that's exactly what Elliot Spitzer did. Now, my question is, why wasn't Elliot Spitzer prosecuted for it? Oh, that's right, he's a Democrat. Forgot about that. For patronizing a person for prostitution. A person is guilty of patronizing a person in the third degree when he or she patronizes a person for prostitution. That's an A misdemeanor. Now, here's the one. Promoting prostitution, definitions and terms. Advanced prostitution. A person advances prostitution when acting other than as a person in prostitution or as a patron thereof, he or she knowingly causes or aids a person to commit or engage in prostitution, or engages in any other conduct designed to institute, aid, or facilitate an act or enterprise of prostitution. Permitting prostitution. For the purpose of advancing it, he or she fails to make reasonable effort to halt or abate such use. Well, wasn't Elliot Spitzer's detail, security detail, state police officers required to report crimes and investigate them? For the purpose of advancing prostitution. Knowingly or aids a person to commit or engage in. Obviously, they all knew what he was doing, believe me. Nothing gets past these security details. They all knew why he was going there. So they are aiding and abetting Elliot Spitzer, the governor, in prostitution. Now, Jim, you thought it was cute asking me whether my cause was worth going to jail over for fighting for the Constitution of the New York State and the federal Constitution. I'm willing to stand up for my rights, not to have them taken away and destroyed by little idiots like you. So here's my question for you. Since you were on Spitzer's team, you were probably involved in this. Did you get, how were the seconds or thirds? Which one did you get? Did you get sloppy seconds or sloppy thirds? You like busting on people? I'm sure everybody would like to know. And why wasn't Spitzer arrested by you or any of the other security detail, knowing he was committing And why did you refuse to investigate corruption, the judges fixing cases, extortion? Talk to me about what's going on. I'll tell you why. You do what they tell you to do because you're a coward. Not only that, you took an oath of office to defend and protect the Constitution. You did neither. That means you're a traitor to both the state and federal constitutions that you took an oath of office to uphold, and your actions clearly show that you're a terrorist because you like terrorizing people, stripping them, having them stripped of their rights. I wonder how, I'll tell you, anybody that's related to Jim Horton has been screwed in family court, give him a big handshake for screwing you over. Because that's exactly what he did. He screwed everybody over because he was too much of a coward to stand up and say this is wrong. Obviously, you don't believe in defending and protecting the state constitution or our U.S. Constitution. And you're probably collecting a pension now. Still screwing the state of New York over. All documentation concerning Justice for New York videos can be found at justicefornewyork.com. There are also family court petitions concerning the right to a jury trial, petitions to vacate support magistrate and judicial hearing officers' orders as they are issued in violation of the New York State Constitution, and there is also a demand for probation reports and psychological evaluations that the court orders, but the court orders that you can't read them or see them. That is a violation of your right to due process and equal protection of the law. They also order that the people preparing these reports do not have to testify and there is no accountability. This has to stop. Demand your reports so you can know what's being told to the court.